Good afternoon, welcome everyone. Before we begin, if you have a cell phone with you, please make sure it is off or on silent. If you have a camera with you, you're welcome to take pictures as long as it's not with a flash. Today's lecture is being video recorded and that will be available afterwards if you'd like. At the conclusion of Professor Weiler's lecture, we will open the floor to questions. Professor Gary Anderson, the professor of Old Testament and Hebrew Bible here at the Theology Department at Notre Dame, will moderate the questions and from the audience and provide some closing comments, I think. This event is a result of a pretty extraordinary collaborative effort, I think. It is sponsored by no less than the College of Arts and Letters, the Law School's program on Church, State, and Society, and its program on Law and Human Development, the Benedict Institute for European Studies, the Theology Department, and the Notre Dame Institute for Advanced Studies.
See, none of them alone would help me.
In fact, what I was going to say is that everybody wanted a piece of the action, really, is what it came down to. It's an extraordinarily large group of sponsors because it is an extraordinary guest who we have with us today. As you know, Professor Joseph Weiler is a university professor in the Jean Monnet Chair at NYU Law School. He's the director there of 3 different institutes, all housed together in a beautiful building right on Washington Square. The Tikva Center for Law and Jewish Civilization.
Right, this is the part I always say, my mother is not here.
Yes, I know. Oh, it gets better. You just wait. The Strauss Institute for Advanced Study of Law and Justice, the Jean Monnet Center for International and Regional Economic Law and Justice. Professor Weiler is a fellow of the American Academy of Arts and Sciences, the recipient of several doctorates honoris causa from different universities, and his publications, among the many, include Una Europa Cristiana, which has been published and translated into 9 languages, The Constitution of Europe, which has been translated into 7 languages, and he's the founder and editor of various very trailblazing academic journals and university programs. He is, not to put it mildly, a giant in the study of European law, international law, and comparative law. And yet, and here is where I apologize for going perhaps further than is my due, but all of those formalities of Professor Weiler's CV don't begin to do justice to the reason why we're glad to have him here at Notre Dame today. They're not the reasons why we're so enthusiastic about his presence. It's rather for other things that make him an exceptional presence, even among the elite group of the world's leading scholars of which he is a part. It's for his capacity to transcend ideological views of law and politics and to break down the rigid categories and conventional views that all too often we're accustomed to receiving uncritically within the academy. It's for the elegance of his writing, for his capacity to engage a broad array of different persons, different groups, different ideas, always. And then beyond academics, it's also for a range of interests and commitments that are a testimony of his breadth of interest in all things human, his commitment to his family, his love of beekeeping and honey, his passion for great music and art and food and wine, the excellence of his teaching. I'll note that he once said, quote, "Though some think of me as a scholar, I consider my professional vocation first and foremost as a teacher, passionate and demanding." His writing, not just of academic books and articles, but even of a novella called Der Fall Steinway. I'm even told, though I've not witnessed with my own eyes, that he loves to ride his motorcycle, which I assume is a Harley. A Harley.
No, it's a BMW.
It's close. His hospitality is legendary. His life is an example of the truth that genuine dialogue and the possibility of understanding among religions comes not from setting aside our respective commitments and identities, but precisely by taking them seriously and engaging them profoundly and sincerely. He has said that the weekly teaching of Bible class at Harvard was his favorite course. He's been a regular participant at the Meeting for Friendship Among Peoples in Rimini, Italy every summer. And I'll note, he's quickly attained celebrity status there, attracting crowds of thousands every time he speaks. He was one of the key figures last year in launching a similar initiative in Cairo, Egypt, of all places. He's contributed to the work of the Pontifical Academy of Social Sciences, and his work on the Lautsi case, which is the basis for his lecture here today, is also emblematic of this same spirit. Many of you will remember his first visit to Notre Dame 2 years ago and his very memorable lecture then on the trial of Jesus. And we're honored to welcome him back to Notre Dame today for this lecture entitled Freedom from Religion. Professor Weiler.
Thank you very much. I'm an Old Testament type. I have a long memory. It's really a pleasure and an honor to be here. And it's a very special audience for this type of lecture, so it means a lot to me. The Lautsi case, which frames my lecture, involved an administrative decree in Italy that went back to the time of Mussolini in the 20s, and has been in fact since then, which requires every classroom in public schools, funded by the state, not private Catholic schools, but in public schools funded by the state, to display a crucifix, just like that one there. And it was challenged by Mrs. Lautsi, who had 2 kids in a school, and she said that requiring her kids to sit in a school room which displayed a crucifix was a violation of fundamental rights under the European Convention on Human Rights. In fact, she first said that it violated the Italian Constitution, but the Italian Constitutional Court refused to hear the case because that was wise of them from a political point of view. They said we only are entitled to review parliamentary legislation, and since this was an administrative decree, it's simply outside our jurisdiction, which meant we don't want to decide this. And the administrative court she lost the case, and that's how she arrived in Strasbourg. And in 2009, I think November, a chamber of the European Court on Human Rights in Strasbourg ruled 7-0 against Italy and said that the requirement to display crucifix in classrooms in public schools was a violation of the freedom of religion provisions of the European Convention on Human Rights, and therefore Lautsi was entitled to damages for violation of her right, and that it was illegal for Italy to have that requirement. The way I want to, so the case then went to the Grand Chamber, that's the highest jurisdiction in Europe in constitutional and human rights matters. The Grand Chamber of the European Court on Human Rights sits in a forum of 17 judges, and it reversed the chamber and held 15-2 that Italy did not violate convention by the requirement of displaying a crucifix in the classroom. The way I want to divide my comments today are as follows. I first want to present some conceptual reflections on the issues that the Lautsi cases raises. To American ears, this sounds surreal. For some, this is paradise. For others, it's hell. But the notion that in a public school you could have the crucifix hanging on the wall just seems surreal. Indeed, when the Grand Chamber decided that it was not illegal and there was no violation of fundamental human rights, there was considerable adverse comment in the United States on the decision, what are the Europeans getting up to, and how could you even imagine that it would not violate fundamental human rights to have a crucifix in the public school. So I want to explain some of the issues in a conceptual and theoretical way that underline the case. And then, in the second part, or the end part, to talk to you a little bit about the strategy that I used in this case in order to try and reverse a 7-0 decision against Italy to a 15-2 in favor of Italy. And the reason I think I have to do it in these two ways, because there are really two different exercises. One is to understand in a serious conceptual, theoretical way what are the issues. I think the court was absolutely right to reverse the chamber. And another thing is how to win a case, and the two things are not don't necessarily overlap. So one of the things that both the chamber, the 7-judge court, and the grand chamber, the 17-judge court, agreed on is that freedom of religion, as understood in Europe and as understood under the convention system, includes in legalese positive and negative freedom, and in English, freedom of religion and freedom from religion. In other words, the guarantee of freedom of religion includes the guarantee of freedom from religion. And I want to raise for a minute, offer some reflections on freedom from religion. It is not self-evident why freedom from religion in a pluralist, liberal, constitutional, democratic state should be constitutionally guaranteed. Now, I know that it sounds at first, how can you even say that? Isn't that going back to theocracy? But I just want to explain why it is not immediately self-evident, or at least why we might wonder if there is freedom from religion, how wide should it be drawn, etc. Now, let us take a state like France, which in constitutional matters, there are many resemblances. They're not identical, but there are many resemblances to the constitutional situation in the United States as interpreted by the Supreme Court in recent decades. So, the French Constitution defines France as republic in Article 1 as republic, social, and laic, secular. By which it means that religion is a private affair, but that the state can in no way, shape, or manner be seen to be endorsing religion, supporting religion. So, a classical example of the French Revolution is the gift of France, of a kind of freedom from religion, because public authority is barred from any endorsement of it. So let's now think, and this is where I try to destabilize this sort of unthinking way which we say, well, if there's freedom of religion, there has to be freedom from religion. Let us think of the wall in a French classroom. The very admirable John Richard Newhouse put into our language the notion of the naked public square. And in my arguments before the European Court, later I thought it was a mistake to do so. I referred to the naked wall of the classroom. But the truth is, it is not a naked wall. Because if there's a communist party in France, let's imagine that they came into power. And let's imagine that they decreed that in every classroom there should be a hammer and sickle. That would not be unconstitutional. If you protested, you were told, next election you win and change the law, have it removed. But it would not be considered unconstitutional to have a hammer and sickle. If you wanted to have the sign of a nuclear-free country, you know, that kind of triangle thing. You could do it. You could pass a law and say every classroom has a sign that we believe in a nuclear-free society. Let's say the Greens came into power, and that would go on the wall. And you could say, this is stupid, this is folly, who wants this? And you would be told, but that's democracy. If enough of your fellow citizens want it, that's what's going to be. On every classroom, on every school in France, primary, elementary school, when you enter into the school, you will see above the door of the school, the gate, the main entrance, Liberté, Égalité, Fraternité, the battle cry of the French Revolution. I sort of like it. I would like my kids to go to a school which had liberty, equality, and fraternity over the entrance. But if I were a monarchist, I wouldn't like it. No, I mean, there are other worldviews who don't subscribe to that. But if I protested and said, why should my kid go to a school which is the battle cry of the French Revolution, I'm against the French Revolution, they would look at me and say, well, form a party, and when you have a majority, you can pass a law which would remove it. We all on the same page? The wall is not naked. Every sign can go on the wall. Every worldview can be represented on that wall. Only a religious worldview cannot be represented on the wall. So instead of calling it the naked wall, we should call it the religiously cleansed wall. Everything is kosher except the cross. How do we justify that? What's the justification that we say the normal rules of democracy allow not only in the symbology of the state, what goes on the wall, but if it's a socialist government, to use taxpayers' money even if I'm a staunch capitalist. Democracy, if the socialists won, they're going to collect taxes and they can use them to further socialist objectives, which I think are inimical to society. What can I do? They won the elections. Next time I hope I will win the election. If they form a coalition with the ecologists, they can use taxpayers' money to further ecological objectives, which I happen perhaps not to disagree. Don't tell my wife I even said that. But I'm just teasing. But that's democracy. And yet, if it's religion, it's taken out of democracy because there's freedom from religion. What's the justification? It's not clear. Now, I'm going to offer one justification. I think it's the most powerful justification. But it still, as a matter of political theory, leaves the standard account of freedom of religion not entirely reasonable. I find the most powerful justification for a robust guarantee of freedom from religion, a religious justification. You will recall that the late and unforgettable Pope John Paul II often used to say, the most important liberty, the most important freedom is freedom of religion. And Pope Benedict has echoed that, notably in his famous or infamous, depending who is doing the reading, Regensburg speeches. Now, you might think, well, what would we expect the Pope to say? If he's the Pope, he says it's freedom of religion. If it was the president of the World Trade Union movement, he would say freedom to strike, or freedom of association. The Pope takes care of his flock, so he says, no, it's much deeper than that. Because when you read Benedict, he says something which is powerful in its simplicity. He says freedom of religion includes the freedom to say no to God. Has to be like that from a religious point of view. It just has to be like that from a religious point of view. Because if we are not internally free to say no to God, our yes to God is meaningless. God is not interested in a coerced yes. Put a gun to somebody's temple and say you believe in God. What kind of yes is that? It's the ability to say no to God which makes our yes to God from a religious perspective meaningful. And therefore, both as an internal matter, but also as an external constitutional matter, if we want to guarantee freedom of religion in a true religious sense, we have to guarantee freedom from religion. If somebody is not free to say no to God, then his yes to God is not a meaningful yes in the eyes of God. So there's a powerful religious reason why every religious person, and that exactly is how the comments of the Pope in the Regensburg speech have to be understood. As a religious leader, I cannot accept a society which do not allow its citizens or residents to say no to God, because I'm not interested in a coerced yes to God. Memorable words cited again and again of John Paul: the church proposes, she never imposes. Now historically that's not always been the case. The church over its history has put many people on the stake in order to force them to say yes to Jesus. But that is the past, and the church has transformed, and now there's a common understanding, and not only among Catholics, that real freedom of religion has to be rooted also in freedom from religion. But that does not resolve our problem. What is the justification from a non-religious point of view, from a democratic, liberal, pluralist, that we would say you can take religious out of politics? Now, I'm not going to address this directly today, but the question may be asked whether a state that consigns religion in its constitution to the private sphere, and therefore even prevents a democratic majority of bringing it into the public square, how do we square that with our religious, with our liberal, pluralist, democratic conviction? In my view, it's been taken so much for granted because of the huge influence in our public consciousness by, one, the French Revolution, and B, American constitutionalism, that we haven't explored sufficiently that issue. Let's nonetheless bracket that for a minute and go back to Lautsi. What would be the case that despite a system which says there has to be freedom of religion and freedom from religion, something that both the Chamber and the Grand Chamber agreed on, you could make an argument that it's not a violation of religious freedom to have a crucifix on the wall in the classroom? Why isn't it self-evident, if freedom of religion includes freedom from religion, that Mrs. Lautsi has to win her case immediately? Because how can it be freedom from religion if her child is forced to go into a classroom in which a crucifix is hanging? And the matter is even sharper if it's not the son, or is equally sharp if it's not just because, for example, they are secular or atheist, etc. But what if they're Jewish, or what if they're Muslim? Why should a Jewish kid or a Muslim kid be forced to sit in a classroom in which there is a cross? Now, this is not Notre Dame. Notre Dame is a Catholic university. You don't like the crucifix? Go to the University of Michigan. My son is a freshman at Stanford. He told me, "Daddy, don't forget to rub it in." He was rubbing it in because he knows that I root for Notre Dame. So we should commiserate together. I want to present the case in a conception. The fact is that in Europe, let's forget America for the next 30 minutes, okay? The world, that's the World Series syndrome. You have a sport that is played in two countries, but when they go to the championship, they say the World Series. 80% of the world have never even heard the word baseball. So let's just bracket the United States a minute. And I want to explain to you the situation in Europe and how the case is built from a conceptual point of view. So the fact is that actually there are two types of religious liberty that are guaranteed in the constitutional landscape of Europe. The first one is the one we've been talking about. Individual freedom of religion and freedom from religion. And of course, and we will get to that in a minute, they're going to be tough, hard cases where the freedom of religion of one person might conflict with the freedom from religion of another person. But let's say all European countries, all 27 member states of the European Union, all 46 states of the Council of Europe who belong to the European Convention on Human Rights, guarantee in their constitutions freedom of religion and freedom from religion, even though there's some margin of appreciation how to interpret it in hard cases. Bracket that, we will get to it. That's a common aspect. But there's a second type of religious freedom, and that is when it comes to the identitarian aspects of the state. Now I'm giving you a snapshot. I'm not conceptualizing or theorizing it, I'm just describing. So on the one hand we have France, which we talked about, the constitution of which defines the state as laïque, as secular, and therefore the constitutional reality resembles to a great degree the constitutional reality you have in the United States. In fact, in some areas they're not as extreme as the United States. But basically, it would be laughable to suggest you could have a cross in a public school. They do not fund religious schools, and all the stuff we know from the United States. The state has to be neutral. You cross the channel. The English call it the English Channel, the French call it La Manche. It's the same channel. And we're now in England. England guarantees freedom of religion and freedom from religion at an individual level. But at the state level, it's the opposite of France. I don't want to call it a theocracy, because that's a word that carries a lot of baggage. It's a non-secular state. The head of state, Her Majesty the Queen, is also the titular head of the Church of England. The Church of England is not just any old church, it's the established Church of England. When soldiers die in Afghanistan and they're brought back for burial, unless the parents require otherwise, the default state funeral is a religious funeral according to Anglican rites or Catholic rites. The Archbishop of Canterbury, ex officio, by virtue of his office, is a member of the legislature, of the House of Lords. And he's not expected to be neutral. He's expected to voice what is the view of the Church of England and its magisterium, so to speak, on the issues that are debated in the House of Lords. That's why he is there. The national anthem in Britain is a prayer. God save the Queen. Give her victorious and glorious. The flag carries the cross. This is a signatory state to the European Convention on Human Rights. About half the population in Europe live in states like France, and about half live in states like the United Kingdom. In other words, when it comes to the identitarian position of the state, we see that with great equanimity, the European constitutional asset accepts both a laïc state, a secular state, a la France or a la United States, and accepts a state where the head of state, the queen, is also the head of the church. Where there's an established church. You know, in this country, one of the ways we differentiated ourselves from the United Kingdom was to say no established church, because Britain had an established church. And Denmark has an established church, and Malta has an established church, and the list goes on and on. Greece has an established church. The Irish Constitution, the very Constitution, speaks about the divine Lord Jesus Christ and the Holy Trinity as the source of all beauty, truth, and justice. That is kosher. Now, we immediately will understand here that the state says, it's up to me to have a cross on the wall if my identity is Christian. And we also immediately see something else, that there can be a conflict and a tension between the right of the state to understand itself and to include in its identity, symbology, and iconography religious elements, and the guaranteed right of individuals to freedom of religion and freedom from religion. So how do we resolve it? On the one hand, we have that collective right which says you can have in England and you can have a France. So if you have in England, we can have a cross on our flag and we can have a cross on our... And we children sing in school, God save the Queen. God, you know, God. And on the other hand, somebody could say, okay, I understand it, but you say that I have a guarantee of freedom from religion. So am I required to sing God save the Queen? That's a prayer. You're forcing me to pray. How is that freedom of religion? Why should I have a picture of a religious leader on the wall, even if it happens to be the Queen? Now, I want to say something about how to think about the resolution of that dispute. And this is very important. And this is also of some theoretical innovation for the lawyers around me. Typically, the way we think of fundamental human rights, why we make them fundamental, is because the equation is between, on the one hand, the power of the state, and on the other hand, the weakness of the individual when faced with the power of the state, even a democracy. The majority can be tyrannical. So we say, therefore, in order to counter the power of the state, we are going to endow individuals with fundamental human rights which even the majority in a democratic state cannot take away with them. These are liberties that are there to protect the individual against the power of the state. And that's why the tradition of all the constitutional, legal, political theory discourse is between, on the one hand, power and on the other hand, rights. In legalese, a very important consequence follows from it. Using different constitutional vocabularies, all constitutional states, at least in what we used to call Western liberal democracies, operate a similar type of scheme. They say, if the state, in the exercise of its power, encroaches on fundamental individual rights, in this country we call them civil rights, in Europe they call them human rights, more or less the same thing, then the state, we have a very particular way of reasoning. The state has to come up with compelling reasons, strict scrutiny, proportionality, least restrictive measure. The whole discourse is there really something very special has to happen. The reason behind the state exercise of power that might encroach on individual liberties which are considered fundamental has to be of a particularly forceful way in order for us to agree to such. If the state said, you know, we're going to say that if a contract is not fulfilled, then it lapses after 2 months, somebody would say, but wait a minute, I signed a... Well, it's not a fundamental right. So If the state is not acting arbitrarily or egregiously, it can do what it wants. But when it violates a fundamental human rights, it's not enough that it's not unreasonable. It has to be compelling. There has to be no other way to achieve not just a state goal, but a very important state goal, a state goal which is so important that it is more important than the fundamental human right that is being compromised. All this is banal. It's common stuff. It's just, if you go to Germany or France or Italy or Canada or the United States, every place you have constitutional democracy with protection of fundamental human rights, it's this type of exercise that takes place. Why do I say this? Because we have to ask ourselves. I said before that I will describe to you the situation in France and the situation in Britain. Correct? But now I want to justify. Why do the Europeans accept that a modern democracy like Britain will have an established church? Isn't that obviously wrong? How can you justify it when at some level the very fact that the Church of England is the established Church of England in some ways encroaches on the freedom from religion of atheists and in some way can be seen as detrimental or prejudicial against Catholics and Jews and Muslims, etc. What's behind it, apart from the fact that history is there? What's behind that is one of the few areas in public law where a collective right is considered fundamental. In the same way that an individual right. Not every right that individuals have in our society is a fundamental. But what is that collective right? It's the right to self-determination. In other words, before we get to the stage of asking what is the relationship between church and state, etc., the subject of the state is the nation. And the nation has a right to self-determination. What does the right to self-determination mean? To understand itself, its own ontology, who we are. Now history comes in. Because in these European states, many of their understandings of who they are, what does it mean to be Irish? What does it mean to be English? What does it mean to be Maltese? What does it mean to be Greece? Is imbued with religious history, with religious symbols, with religion. And therefore, to deny them the ability in the manifestation of the nation and the state to excise, to cleanse all religion, identity, symbology, is in some way to deny their fundamental collective right to self-determination. Examples are always useful. One cannot understand the meaning of what it is to be Irish without reference to Roman Catholicism. Their struggle from independence from Britain, in part, was a struggle of Catholic minority against the Protestant majority. It's not surprising that in the preamble to their constitution we have the Holy Trinity, the divine Lord Jesus Christ, etc., etc. Even an atheist Irishman or woman, even a Jewish Irishman or woman, if asked to say what does it mean to be Irish, they would say you cannot begin even to explain it if you don't make reference to Roman Catholicism. I don't like it, I do like it, but it's a fact. That's how the nation understands itself. The same thing in England. To say there's an established church, the Queen, etc., William and Kate get married in Westminster Abbey, the legacy of the Church of England is part of what it means to be English. England is essentially a secular society. There are more people every weekend that go to worship in a mosque than go to worship in a church, just as a sign of the secularism of England. But if you were asked to ask the English, do you want to disestablish the Church of England? Do you want to change the anthem, to drop the guard? Do you want to change the flag, to drop the cross? He would say no. Why not? You're an atheist. You never go to church. You don't care about, but I'm English. And that's part of what being English means. But my anthem is God Save the Word. It connects, God Save the Queen. It connects me with, it's like, do you want to give up the Queen? But you're a Democrat. Yes, but to be English is also to have a monarchy. And I could give you endless examples. Greece, the entanglement of Orthodox, Christian Orthodox Church with the identity of the Greeks, their struggle against Turkish domination for centuries, is part of what it is to be Greek. Now, two things follows. First of all, there was a period where to be English was to be anti-Catholic and chop their heads off. But we've moved on. So now the constitutional settlement in Europe is to say, you're entitled to vindicate the religious aspects of your identity in your collective identity, in the symbology of the state, but you have to guarantee individual freedom of religion and ethnic. No more chopping off Catholic heads. No more discrimination on grounds of Catholicism or grounds of Jewishness or Islam or atheism, etc., as in the past. There's an exception to that. The Queen has to be Church of England. Sweden disestablished the Lutheran Church as the official church of Sweden. It's a very powerful example because it happened recently. It's not 200 years ago. But they still kept in the constitution, the Swedish king has to be evangelical Lutheran. Could somebody go to an employment tribunal and say, wait a minute, that's discrimination on grounds of religion? He would be told, no, the king is a symbol of the state. Not a job, it's the symbol of the state, and we understand Sweden in some way to be tied up with evangelical Lutherans. And that's why, even though we disestablished the church, we still insist that our king be an evangelical Lutheran, because somehow if he was something else, that wouldn't be Swedish. They're not going to check if he actually believes or not, but officially he has to be an evangelical Lutheran. Where's the theory game? Because when it comes to the clash between the identity of the state as reflected in religious symbology and freedom of religion and freedom from religion, it is not, in my analysis, the classical conflict between power on the one hand and rights on the other hand. It's a very different equation. It's rights versus rights. So the individual right does not trump in the same way the public power. Because in this instance, the public is not just vindicating its power interests, its policies, etc. It is vindicating something very fundamental, the right to self-determination, its very identity. So now let's see how we can accommodate these things. So instead of talking about the cross, let's imagine that in an English school, in assembly, every morning, they sing the national anthem. That can resonate with the United States. It's a country where the national anthem is sung regularly. What if a kid came and said, on grounds of conscience, freedom from religion, I don't want my kid to sing the national anthem? I think it would be a violation of the fundamental right to freedom from religion as an expression of freedom of religion if one said if she doesn't sing the anthem, the prayer to God, she will be expelled from the school. But if she came and said, in the name of my freedom from religion, I want to forbid everybody else from singing the national anthem, this kind of accommodation between right and right, one would say no. With all respect, you can vindicate your right by not singing it, but you can't require others not to sing it, because they are vindicating part of the collective right of self-determination to this kind of identity. It's trickier with the cross. It's trickier with the cross. But the court insisted on the passive nature of the crucifix on the wall. What did it mean by the passive nature? It says, doesn't say, but it's implied. If you were not simply, there was not a requirement of a cross on the wall, but people had to turn to the cross and bow their head. That would be forcing people to engage in a religious act. That would be coercion. That would violate their fundamental right to freedom of religion. As I said, even a good Christian would not require such, because to be forced to bow to the cross, that's not a meaningful yes, if it's a coercive yes. But the individual, if they can just disregard the cross, etc., should not prevent the state from vindicating its symbology, its identity, even if it happens to have a religious dimension to it. You cannot, in the name of freedom from religion, say to Britain, you have to change your flag because there's a cross in it. You have to change your national anthem because there's a cross in it. You cannot say to the Germans, you cannot read or hang the Constitution of Germany on the wall because it starts with the words, aware of our responsibility before God. You might not think you have responsibility for God. We should not coerce you in any way to do anything that symbolizes that you're accepting any responsibility before God if you don't accept God. But if that's the self-understanding of the German people, that there is some kind of transcendent truth beyond, etc., it's for them. And that, now I come back to forget that owe you from the beginning. This is one justification for the laïc state. When the French come together, they say our understanding in the historical context is exactly the opposite of the Irish. We were so sick and tired from the complicity of the church with the Ancien regime that part of what we understand ourselves to be, to come together as a French people, is religion is a private affair. We don't want to be a people in which religion is a public affair. That's part of our collective identity. That is our vindication of our right to self-determination. It's tricky, but it's not specious. For a people to be able to say, we will defend your right to worship, freedom of religion, but as a people, just as the British understand themselves as, or the Irish understand themselves that there's a religious dimension to their collective identity, we the French, with the same kind of conviction, want to understand ourselves as a people in which religion is a private affair. Not without problems, but not a specious argument. So, let's bring this part to a hold and now quickly say something about the case. Do we have it on? Yes. But first, I want to show you what the Grand Chamber is like in all this. Let's that you get the setting. How do we do this?
Yeah.
Do I have to do something here?
That's what we're waiting for.
Just a few seconds. Is waiting for Godot or?
Where's the keyboards maybe?
While he's doing it, I will. So, let's forget the theoretical construct. I was shocked by the 7-0 decision. Why was I shocked by the 7-0 decision? Because there was an incongruity for me in it. The reasoning was incredibly weak. In part because of the arguments of the Italian government. The Italian government went into court to the chamber and said, the cross is not a religious symbol. It's a national symbol. You know, like the Red Cross. Everybody understands the Red Cross is ambulances. They don't associate it with Christianity. So they said the crucifix, look, it's not just a cross, it's a crucifix, it's the Italian cross. That's not a religious symbol. That's a national symbol. And therefore there's nothing that... Of course they gave the game away, because the minute the chamber could find that actually a crucifix is a religious symbol of no small magnitude, and by their own admission, Italy said, by implication, if we're arguing that the cross is not a religious symbol as the way of defending ourselves, the implication is, if you find that the cross is a religious symbol, then we've lost our case. So not very helpful. But that was not only the weak part of the decision, it was the concept of neutrality that said, in no shape, way, or manner can the state endorse any kind of religion or the legitimacy of any kind of religion. That was at the heart of the decision of the chamber. And if that was at the heart of the decision of the chamber, then obviously the cross was a violation of the convention, but obviously that could not be right. Because if that were right, then half the population of Europe would be living in states which violate the convention. So an extraordinarily weak decision, wrong on its face, and yet 7-0. And yet 7-0. So my view as a legal realist was that the problem was the internal culture of the court and the culture of human rights, etc. That there must have been 1 or 2 or 3 judges who said, this is not possible. But somehow they could not bring themselves, because to defend the cross on the wall would cost you as a reactionary, as clerical, as going back to the past, etc., etc. Let's stop now soon. Okay, but we will start showing it just in a minute. I want to finish explaining this. So, there were 8 states that intervened in this decision, and they asked me to represent them. Unfortunately, I had to do it pro bono. Not because I have such a big heart. The reason I did it pro bono, that wasn't... My wife to this day doesn't quite understand that. But can you imagine if I had charged my normal fee, every blog around the world would say, look at that Jew. For money, he would even defend the cross. You think I'm joking? I'm most serious. That's the reason I did it pro bono. Because I couldn't afford that kind of accusation. And you know, and I know that you know, and I know that you know that I know that you know, that this is what the blogs would have said. This is what some of you would have thought. So I had to do it pro bono. So my task was not to find the legal arguments, the winning legal argument. Because as I explained, it's not such a difficult argument to be made if you just examine the constitutional landscape. My task was to make them understand that to defend the right of Italy to have the cross on the classroom was to be on the side of the good guys, the tolerant guys, the pluralist guys, the guys who are doing the right thing. Because I thought that only in that way would I be able to allow them to come up and actually see that from a legal point of view the arguments are not so complex, and that it was not regressive, that in fact the regressive position was the position of Lautsi, because what Lautsi and the chamber wanted was to have the whole of Europe be like France. And I was plugging the argument that the strength of the European position was that it allows a France and it allows a Britain. that it allows a variety of ways of engagement of church and state at the identitarian level, whereas at the individual level, there's a common asset of freedom from religion and freedom of religion and freedom from religion. That was the task. Now, my clients were at first very unhappy with this, because when I met them and explained my strategy, they said, but where are the legal arguments? And I had to say to them, it's not about the legal arguments. You win this type of case, you win by convincing them that they are doing the right thing. Because if they are convinced that they are doing the right thing, it's very easy to come up with the legal arguments. And the legal arguments were nuanced. In my own arguments at the end, I said, you are not giving an unfettered license to have religious symbols in public place. There might be circumstances, I don't know, a neighborhood entirely made of Muslims, where they could say, at a minimum, let's have also a crescent on the classroom. But I said, it's up to the individual to prove that having a cross on the classroom is oppressive, is inimical to education, is a denial of the freedom of education, etc. You cannot say that per se having a religious symbol in a public space, including a classroom, is a violation of the convention. And indeed, it's a moderate decision in that respect. But the real issue, and it was very difficult to, and at the end, just in exasperation, I said, but so why did you turn to me? I mean, obviously you came to me because you thought I could win this case for you. So they gave up. Now I will tell you something very funny. The worst 5 minutes in my professional life. You know, I've done lots of arbitration, I've represented states and so on. So the decision, I joked, nobody believed you could win the case. To overturn a 7-0 decision of a chamber has not happened before. In fact, it's hard to get to the Grand Chamber against a 7-0 decision. So I once quipped, I said, if I win the case, I walk on water. Somebody did that before. So they issued their decision on a Friday afternoon. So since I observed the Sabbath, I couldn't go to the court. I had to write a letter of apology because it's customary that the lawyers are there when the judgment is read. I had to apologize to my clients and so forth. And then I was sitting in my apartment in Paris in front of the computer, and 3 o'clock in the afternoon, and uploading and refreshing. And the judgment didn't come up, because the court decided they would read the judgment. It was a huge judgment. They had to move to the main auditorium of the building, because there was so much press, etc. And so somebody texted me, 15-2. And I just, I said, how can I ever show my face in public? I've only persuaded 2 states. There I was arguing, legal realism, blah, 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 all my strategy. And now I lose 15-2. Only 2 judges was I able to persuade. And really for 5 minutes I was thinking, will I do it with cyanide or with sleeping pills? And then you go to the Eiffel Tower and jump. And then after 5 minutes, the emails and the text messages started flashing in, congratulations, etc. So get a sense of how it was on the actual...
Mr. Alberto.
In States, I give the floor to Professor Weiler. Mr. Weiler, please.
May it please the Court, I have the honor to represent the 8 intervening states, all of whom are of the opinion that the Second Chamber erred in its reasoning and interpretation of the Convention and in its subsequent conclusions. I've been instructed by you, President, that the third parties may not address the specifics of the case, but should be limited to the general principles underlying the case and its possible resolution. And so I shall do. This case is not only about the crucifix, it's also about the tension between individual rights and collective identity, the tension between the role of courts and of political democratic institutions. You get the idea. So there it was. And so the arguments went, and the rest of the story I told you. Now a little coda. The hate mail and the fan mail. So you can imagine, I just got a huge amount of fan mail and a huge amount of hate mail. And they said exactly the same thing. The fan mail said, "Thank you for defending the cross." And the hate mail said, "How could you defend the cross?" And I wrote back the same thing to both of them. And I said, I did not defend the cross. I defended the right of France to be France and of Italy to be Italy. I defended freedom of religion and freedom from religion. That's the position I took. I defended a pluralist Europe in which democracy and religious identity are not held to be inimical to each other. A state can have a religious identity and yet still be a card-carrying member of the club that protects fundamental human rights and is part of the family of nations. I got a lot of Jewish hate, and I replied to them always in the same way. A little bit more elegantly than I'm saying now, I said, in all Israeli schools, there is, on every school in Israel, Jewish, Arab, Christian, there is the symbol of the state, the menorah. And in every school in the Jewish sector, even in secular Tel Aviv, there's a mezuzah on the door. Or would you say that Israel would be required to remove the menorah from all the schools in Israel and to remove the mezuzah from the door? If you say no, then we really have nothing to talk about. Why is something allowed to Israel should not be allowed to Italy? If you say yes, then let's discuss it. I never got a single reply to that question. Ladies and gentlemen, thank you very much.
Thank you so much for a wonderful lecture. We apologize for Notre Dame problems with technology, but we got it working in the end. Professor Weiler has agreed to take some questions, and as is the custom in the law school, priority will be first given to students, and we'll also have time for faculty questions as well.
I consider myself a student in this context. Since you've spoken of realpolitik, I have the following question. I understand from Paolo that you have some credentials that arguably prepared you professionally to be called upon to present this argument. But if I were states in Europe that wished to be free to post the crucifix on my school walls, and I wanted to have an advocate before the European Court of Human Rights, I would think that picking a prominent non-Jewish advocate would be a good piece of realpolitik.
A non-Jewish one? A Jewish one or a non-Jewish one?
Non-Christian, I'm sorry, non-Christian.
Okay. That was an interesting Freudian.
Do you think that had anything to do with your selection?
I think what primarily had to do with my selection was the fact that as editor-in-chief of the European Journal of International Law, which is the leading journal of international law in Europe, I say it's the leading journal of international law in the world. I think the editors of the American Journal would contest that. But I'm happy to be number two. When the chamber decision was posted, I was so outraged. I published an editorial which said, no matter where you stand on this issue, this decision is an embarrassment. It's a simple legal embarrassment. And it's an important journal, so my editorial made the rounds. And I think that's why they came to me because of that. I also think that it did give them probably some credibility that an openly Jewish law professor would be arguing in the name of freedom of religion, etc., that the cross can be on the wall. Yes? I didn't think they thought they were going to get it for free.
Thank you very much for a great lecture. I'm really happy to hear somebody who's coming from the American context speaking of Europe as a very complex region in terms of religion and secularism. The question I have has to do with another conceptual aspect of this case and other cases that deal with churches of cross in the public sphere or any kind of religious symbols. And that's a question about the meaning of religion, the notion of religion. And I came a little bit late, so I'm not sure if you addressed that at all, but if you could comment on that and say something about what this particular case would imply about the ways in which we think about religion as such, or religion as a notion in relation to the question of secularity and secularism.
It's a good question, but I don't think this case has too much to say about that. I think there are other very, very interesting cases which this court or other courts, the most interesting case in that respect is the case of the Supreme Court of the United Kingdom, what used to be called the House of Lords, in the JFS case, which I discussed this morning with a group of your undergraduate students. Because in that case, when the chief rabbi of Great Britain was accused of being a racist, was found by the court to be a racist. And by implication, Judaism was found to be racist by the Supreme Court of the United Kingdom. That was a very interesting case because it was implicit and in that decision, erroneous and terrible decision, was based on a conception of religion. And we don't have time, I think, to go into that case. But the bottom line is that the court's understanding of religion was Christian and Protestant. It was poorly. So, according to which, you remember, the one radical way in which Christianity broke away from Judaism was when St. Paul says, there is no longer Jew or Gentile, man or woman, free man or slave. Everybody is saved in Jesus Christ. For a Protestant Christian, the position of Catholics is a little bit more nuanced and delicate. If somebody says, I don't believe in Jesus Christ, it's like saying, I'm not a Christian. And if somebody says, I do believe in Jesus Christ, that's what makes you a Christian. The understanding of religion is of faith. I think Catholics are a little bit more nuanced. If somebody said, I don't believe in Jesus Christ, you would say, he's a lapsed Catholic. And in that respect, it's closer to Judaism. Because Judaism, by religion, it's not a sociological fact, it's a religion definition. If somebody is to blame, blame God. It's religion, but also peoplehood. So, in the JFS case, there was a situation that there was one kid who went to synagogue every day, was very sincere about his faith, and from that Protestant Christian community, he was a very good Jew. And next to him is another kid who is openly an atheist, never goes to synagogue, and says, I don't believe in God. The first kid is not admitted into the Jewish school because he's not formally part of the Jewish people. Because the conversion of his mother was not kosher. So, by the Jewish definition of peoplehood, he's not a Jew. And the second, despite him going to synagogue and sincerely understanding himself to be Jewish and eating kosher and all the rest. And the other kid is admitted to the school because he's part of the Jewish people. To the Protestant majority, no, I don't want to say the Protestant majority, of course there were Jews there, to the majority of the Supreme Court, that meant that Judaism is racist. Because if the kid is admitted because he's Jewish simply because he was born to a Jewish mother, he's considered a Jew. And the other kid who was born to what, according to Jewish law, was not a Jewish mother, he's not a Jew, even though from a faith point of view, they said, you see, that's racism. It's a racial criteria for admission to the school. That's the case to look at if you're interested in how concept of religion informs the decision. I don't believe that Lautsi really goes down, or really there's much to glean from it. we can glean everything, something from everything, but I don't think that's the real deep. The real deep. It's not the richest pickings from that case.
Thank you so much for a splendid lecture. I have two questions that are interrelated. The one is your basic philosophical argument was that the identity of a state can trump individual rights. The question is, there must be a limit to that. Let's assume the Spartan polity. It was crucial for them to have the crypteia, which means to slit the throat of helots on certain days of the year. It was the way how the Greeks perceived that what it means to be a Spartan. Let's assume the Spartan polity had survived into the 20th century, and they would say, we have done it for 3,000 years, it's how we define ourselves. We would say, I'm sorry, this doesn't pass the European Convention for Human Rights. So the question is, where do we have the exact limit to say when the identity of a state is not allowed to trump the individual rights? And the second question is the application to that. As you know, the crucifix case had, how can I say, a prelude in German constitutional law. Because in German constitutional law, which is, by the way, has a strange intermediate position between the French and the British case, because we do not have an established religion. However, all religions have the right to become public institutions, following a certain procedure, which expresses, on the one hand, the belief of the state that religions are very important in the public realm, but at the same time, the idea that the state cannot commit itself to fostering any specific religion. In the German situation, it was so that in the 1950s, as far as I can remember, the Constitutional Court had to judge that the crucifixes had to disappear from the courts. And it was a Jew who brought the case to the Constitutional Court. His argument was in Germany, in order to settle damages connected to the Holocaust, said, I do not want to have the discussion of this problem in front of a crucifix. And the Constitutional Court agreed they have to left. It remained in schools. And then in the 1990s, I don't remember the exact year, the argument, it went to a question where it could remain in schools, and the Bavarian state law regarding crucifixes in school was regarded as anti-constitutional because it was said by the plaintiff that his right, his negative right of freedom, of religious freedom, was infringed upon by the obligation to look at that. The new law that then Bavaria passed was not a law that took out the crucifixes from the Bavarian schools, but said, if there is a complaint in the school, then there must a certain procedure be followed. And this law is still valid, even if some constitutional lawyers have doubts that it is compatible with the judicature of our constitutional court. So my question to you is, where do you draw the line when individual rights cannot be trumped by the identity of the state? And what do you do of a German specific case? I know it's not exactly your province because my question is not always that the German decision have been made on the basis of the European Convention, but what do you make of the two German decisions in the 50s and 90s?
So, where to draw the line? Now, I said to all of you, my answer might appear to be a cop-out, but it's not. It's very serious. It's not possible, and I know that for German jurists sometimes this is an existential crisis. It's not possible to say where exactly I will draw the line. But it is not. I'm not trying to be funny in both my comments. It's not an issue unique to the identitarian nature of the state and the individual right to freedom from religion. Very often we pit one individual right against another individual. We allow freedom from religion, freedom of religion, but if somebody came and said, in the name of freedom of religion, God revealed himself to me yesterday and said to me to take my son, my only son, the son I love, to walk 3 days into the desert, to see a mountain, to go to the top of the mountain and to sacrifice him, we will say, yes, but not in our state. You do this, it's attempted murder. You go through it, it's murder. And it won't help him to say, but freedom of religion, God told me to do it, and my name is Abraham. Sorry, Abraham. There are limits to freedom of religion. If I asked you, where do we draw the line? I can't give an advice. I am pitting one right against another. We don't allow female circumcision. We do allow male circumcision. In some countries, kosher and halal slaughtering is permitted as an expression of freedom of religion. And in other countries, it's not permitted because it's considered too much of an encroachment of animal rights, etc. So where do we draw the line? We can never say, not even the German Constitutional Court will say. When they engage in their famous proportionality, they simply ask themselves the question, is the interest on the one hand of the state so important as to override the interest of the individual? My thesis was not that the identitarianation of the state trumps fundamental rights. That when we do that equation, we should not do that equation in the normal way, power against right, but right against right. Which means the line might be drawn a little bit differently than if it was power against right. But exactly where I am to draw the line, I don't know. And they don't. That's exactly where we give that leeway to our constitutional courts. In where they go to draw the line, they're defining our moral identity. And we ask them to do that because we can't draw that line ourselves in advance in many cases. Which in a felicitous way leads me to the second case. It is understandable to me why in Germany, of all countries, with the Holocaust in its background, if there's a Jewish plaintiff suing the state for damages for the Holocaust, they would be sensitive and say, yes, you take the cross off the wall. This is inappropriate. I can understand why in the United States the police will defend a bunch of neo-Nazis with swastikas marching through Skokie, a neighborhood of survivors, vindicating freedom of expression as a defining liberty of the American polity. And why a similar demonstration in Munich? The police would be in prison within 5 minutes. Can I say, how do we draw the line? I can't say exactly, but it's understandable for me why in Germany there's one outcome and I support it, and why in the United States there's another outcome and I support it. So it's not possible to say. The only thesis I advance to you is that the line should be drawn when the judges draw the line, when they weigh the interest of the state and the interest of the individual. They should not do it in these cases in the normal way of simply saying there's power and interest on the one hand and fundamental rights on the other hand, but there's a fundamental collective right on the one hand and a fundamental individual right on the other hand, and that should impact the decision. Where the line would... The decision of the 90s of the Bundesverfassungsgericht, which Dieter Green is very, very proud, he sees it as the crowning achievement of his tenure on the court, is consistent with Lautsi. Why is it consistent? What the Bavarians are doing, they might be cheating a little bit. But essentially what the position is, we are not saying that in all circumstances the cross can be on the wall. Because if there might be circumstances, contingent, depending on the demography, the geography, the history, the locale, etc., where the cross will be inimical to the well-being of the kids, to the atmosphere of learning, it would be oppressive or prejudicial, etc., I can argue that. And I balance it by saying I'm not willing to say that in all circumstances when the cross is on the wall, it's not kosher. So, in a way, the Bavarian position, which I think is consistent with the decision of the Bundesverfassung, believe me, I've read it from the beginning to the end and from the end to the beginning, etc. It's that kind of accommodation. It's an understanding that there are two interests here. And that we see this all the time. We see this all the time. The society might say, we give a right to abortion, but many Western societies do that. But I don't think it's in the spirit of accommodation when they say, but we will put in prison a doctor who refuses to give an abortion, or we will take away his doctor's license. You can draw an accommodation would say, a woman might have a right to abortion, but a doctor should have a right to a nurse to conscientious objection to not participate in abortion. I find it, so it's exactly understanding that there are fundamental rights and interests on both sides, and you just have to find an accommodation between them. And that's why I can't draw the line in answer to your first question. And actually, what the Bavarians are doing are, in my view, consistent with the prudential approach of Lautsi. It's not per se violative, but it's not automatically in all circumstances okay.
Yes, thank you very much, Professor Weiler. I wanted to raise a theological concern about the theoretical part of your talk, which goes to the question about the nature of religion. I mean, I could imagine a Christian objecting to defining the cross as a passive symbol for the self-determination of collective identity of the state by saying, well, the cross certainly isn't passive, but it's active. It makes a claim on one. And it's a stumbling block, as Paul says, or something like this, and that there's a kind of evangelical sort of moment about the cross as a symbol, which makes it different from any other symbol. So I wonder then if you can so easily separate the cross from this kind of evangelical mission, which is what secularists are worried about, and why they, I think, may have some good understandable theological reasons even to sort of question whether this is really passive. And also something that Christians will be worried about. And then the second part to go along with this is that thinking of the cross as a vehicle for self-determination of the state also seems to turn it into something of an idol from a theological perspective, because I don't want the cross to be a vehicle for the self-determination of any state. I want it to be a symbol of God, right, and God's sort of love for humanity, et cetera, et cetera, et cetera. So again, it's not passive. It's making a very strong claim, and it can't be so easily sort of taken up as a banner for England or whoever. So I think, as a theologian, I might object to putting a cross in a public school.
Me too. Me too. But to the evangelical, the first part of your question, I would say, we would never dream of forcing you or preventing you from thinking of the cross the way you think about it. But what we will prevent you is from forcing others to think of it the way you think about it. You don't own the cross. So you are free to think about it as an obstacle, as a powerful, proactive, dynamic symbol, as not passive at all, that's fine. And when you walk into the classroom and you see the cross there, that will be your understanding of the cross, and that's also fine. We have no objection. The cross can mean different things to different people in different circumstances. What we will not allow you is to, in some way, in any way, coerce somebody else to see the cross in the way that you see it. And same thing happens. I, as a religious person, can say I really find it bad for Christianity that the secular state, Italy is a laic state, that the secular state takes the cross and appropriates it as part of its national symbology. And my answer to him is, get a majority and stop it. Remove the cross from the classroom. But it's part of the freedom, it's part of democracy for people to take that religious symbol. They're not making it part of their collective identity. So I sympathize. I understand what you're saying. Actually, that's close to, I am very, very on the side of, I'm afraid of any, I don't like the state entangled in with religion from a religious point of view, because the state is so powerful. I'm afraid that they start giving me money, then they will start putting conditions, etc., etc. Although, ouch, I have 5 kids, private religious school. Oh. Vouchers, please. But on the other hand, it's not, in a pluralist democracy, you and I also believe in pluralist democracy. So we believe in freedom of religion in different ways, etc. I objected to the rule of the state of New York, which seemed to authorize only one kind of kosher certification for kosher food. Because I was saying, why should you, the state, intervene in the kosher wars in the Jewish community? It's not for you. Please keep out of it. So it's in the same way that evangelical can see the cross in one way and others can see it in a different way. I would not want to restrict their ability to see it in this way. I would want to restrict their ability to force others to see it in the way they see it. That's exactly the negotiated line between freedom of religion and freedom from religion, and the ability of the state in its symbology and iconography to understand itself as using religious symbol or even being religious, and at the same time not coercing any individual into religious practice. So, for example, the fact that in Israel there cannot be civil marriage is a gross violation of human rights. People, in order to vindicate their fundamental right to create a family and get married, have to go through a religious ceremony. Worse than that, it doesn't get. In terms of, but on the other hand, if somebody says to me that very notion of a Jewish and a democratic state is incompatible with the principles of liberal democracy, I would say that's nonsense. Half the population of Europe live in states like that. Just about knowing where to draw the line.
Thank you. I think we should probably bring the afternoon to a close. I think what you've explained so well is what many of us know about you, your combination of extraordinary learning, respect for international law, great logical rigor, and bringing that learning to bear on a particular legal problem. But I think what's really come out this afternoon, and especially the questions-answer period, is that you're not reduced to simple binary on this question or sound bites. And even a 5 or 6 paragraph article on this Lautsi decision is not going to do justice to the very fine ways in which you want to cut the logical reasoning that's at stake here. I think that's extraordinarily commendable. I think most of the people in the room, maybe speaking for all the people in the room, were tremendously taken by your address and your humanity and the way in which you handled this very delicate problem. I commend you for it personally, and I hope all of us will warmly could thank you.
Gary.